Hello, everybody. I am Amy Wildermuth. I'm the dean here at the University of Pittsburgh School of Law, and it is my great pleasure to welcome you to the McLean Lecture, which is the law school's premier lecture on international legal matters. Now, our speakers for this lecture is just first rate, and I have to say that includes today's very special speaker. We have had two judges of the International Court of Justice, members of the Nuremberg prosecution team, the first woman judge on the European Court of Justice, former attorneys general of both the United States and Canada. This is an outstanding event, and I am so excited that you are all here today with us. And of course, this whole event is arranged and hosted by Pitt Law's Center for International Legal Education, or CILE as we call it, which is celebrating its 25th anniversary. What a day indeed. So CILE is the home for many aspects of international and comparative law programming throughout the law school, teaching, scholarship, and outreach. It is the home to the LLM and SJD degree programs at Pitt Law, and it provides opportunities for students and faculty to engage the world and prepare for careers that span the globe. The center provides programming both in Pittsburgh and throughout the world, including the training of students throughout the Middle East for the annual VIS International Commercial Arbitration Moot Competition, which will be held later this month in Vienna. So it's my great pleasure to now hand things over to the leader of CILE, Professor Ron Brandt, who's going to introduce one of our fabulous alums, Marketa Lindt, who will speak to us shortly. Welcome, everybody. Welcome, Marketa. We are so excited to have you here. Ron, I'll let you take it over.
Thank you, Amy, and welcome everyone to the University of Pittsburgh School of Law and to the 28th McLean Lecture on World Law. As Dean Wildermuth said, this is the premier lecture series on international legal matters at the School of Law and has brought in a wonderful group of speakers, but none better than the speaker we have today. This is part of the celebration of the 25th anniversary of the Center for International Legal Education. We've been doing monthly events. I want to mention quickly two of them to highlight them and hope you'll join us. On April 8 and 9, we'll co-host a conference on sovereignty, humanity, and law with the Law and Humanities Institute, with a wonderful interdisciplinary set of panel discussions and a keynote address by former U.S. Ambassador to the EU, Stuart Eisenstadt. On May 18, 19, and 20, we'll co-host a conference on deals and disputes, China, Hong Kong, and commercial law with Pitt's Asian Studies Center. Again, we have a stellar set of panels and keynote addresses scheduled for that. You can find more information on all of those at the website law.pitt.edu/CILE and click on Celebrate with Us. The Center for International Legal Education and Pitt Law are proud to continue the tradition of the McLean Lecture, which was created to honor the legacy of Mac McLean. Mac was a Pittsburgher and a founder of the World Federalist Association, both in Pittsburgh and around the world. He was also a vibrant part of the Pittsburgh international community and was dedicated to the idea that the expansion of the rule of law and the creation of a functioning international legal system is the best way to ensure lasting peace and justice throughout the world. Each year, the McLean Lecture provides insight into the importance of law to global relationships and to individuals' lives and to peace. For the 28th McLean Lecture, we hear from one of our own about a topic of critical importance. This is a part of our spotlight on our graduates during the anniversary year of CILE. Again, you may find more from our graduates in our CILE newsletter, which is also on our CILE website. As is our practice, following the lecture, we will take questions from the audience, so please use the Q&A function to submit your questions for this purpose. Our speaker, Marketa Lindt, is a 1994 JD graduate of Pitt Law and is now a partner at Sidley and Austin's Chicago office. where she specializes in immigration law. Her work involves the representation of U.S. parties seeking to hire and retain foreign national employees, compliance with immigration laws generally, and advocacy efforts in the process of drafting and implementing U.S. immigration law and policy. From June 2019 until June 2020, she was president of the American Immigration Lawyers Association. She also serves as a member of the U.S. Chamber of Commerce Immigration Policy Committee. Ms. Lindt is recognized by numerous organizations as one of America's leading practitioners of immigration law, including as an immigration trailblazer by the National Law Journal. She recently received the Marjorie Mattson Woman of the Year Award from the Pitt Law Women's Association in recognition of her contributions to the legal field. She speaks regularly on immigration law matters and is a primary author of the Immigration Law and Practice Treatise, Business Immigration Law, and she has written widely on workplace immigration issues. Ms. Lindt has consistently demonstrated a commitment throughout her career to providing access to counsel for underserved immigrants. She advises a number of Chicago area cultural institutions and organizations that provide assistance to underserved immigrant populations, and is a member of the leadership board of the National Immigrant Justice Center. Marketa has titled her presentation today, Cleaning the Sand Out of the Gears, Unwinding the Trump Administration's Extraordinary Use of Executive Action to Restrict Immigration. That may be the longest title we've had for a McLean lecture. The presentation will be conducted in an interview format. So let's begin. Marketa, welcome back to Pitt Law. It's great to have you with us.
Thank you, Professor Brandt. It's really a pleasure and an honor to be here at Pitt Law for the lecture, and I'm looking forward to this morning.
Good. Now, well, I provided an introduction that includes your recent activities in life, perhaps particularly for the students who are with us. You could say a bit more about your journey from Pitt Law, and you were also a master's degree from our Graduate School of Public and International Affairs. Can you say a bit about your path from here at Pitt to your current position as an immigration lawyer at Sidley?
Certainly. So I actually specifically decided to attend Pitt because of the joint degree program between the law school and USCIS, because at that time, my plan was to work in international human rights and particularly on refugee issues, which I was very interested in. And while I was at Pitt, both at the law school and at USCIS, I took every class on constitutional law and human rights that I could, tried to look at it from a legal and a policy angle. I took every class on international law, including yours, Professor Brandt. And while I was in law school, this was the time of the Haitian refugee crisis. And together with some other students, we traveled to Miami over spring break to volunteer with the Haitian Refugee Center to prepare asylum applications. And I just really became hooked on immigration and the intersection between immigration and human rights. And while I was at Pitt Law School, I had the opportunity to do some other really, really interesting work in the area of human rights. I did a refugee research fellowship for the Red Cross Research Institute in Geneva, Switzerland one summer, a human rights monitoring trip to Mexico during the Zapatista Rebellion, if anybody remembers that. I traveled around Czechoslovakia to educate the Roma population about their rights as citizens. And I also served as a research assistant to Professor Jules Lobel on a project on economic rights. And I continue to develop my interest in immigration and in human rights. And while before graduation, I had an offer on the table from an immigration law firm in Pittsburgh where I'd been clerking, I came across an opportunity for a job doing community education and advocacy on immigration issues for a nonprofit in Chicago. And I figured I was still young enough for an adventure and decided to take the job with the nonprofit in Chicago. And so that was a fork in the road for me. It was a great decision for me professionally and personally. I really was energized and loved working in the immigrant communities in Chicago and with the immigration advocacy scene nationally that I became involved with. And I do love Chicago, and it's now my home, although I do miss Pittsburgh a lot. I miss the hills and the neighborhoods. And I know Chicago is very well known for pizza, but I definitely still miss Minio's, which I still think is the best pizza around. But in any event, I worked in the Chicago immigrant neighborhoods and then took a job as an associate at a small immigration law firm in Chicago. I wanted to go to court and litigate cases and represent people in the immigration system, and became at that time very involved in the local chapter of the American Immigration Lawyers Association. I was a very young lawyer at the time, so I thought I could be helpful organizing volunteer and pro bono events. And I was able to meet a lot of people that way, doing all kinds of interesting work in the immigration field. And that's actually how I met the immigration lawyers who worked at Chicago's office of Sidley Austin, which is a large law firm, a global law firm with the immigration group based in Chicago. And when a job opened up in the immigration group, they reached out to me, having gotten to know me through those volunteer activities, and offered me the job at Sidley. So at that time, given my background in human rights work, I wasn't sure whether the big law firm environment would be the right fit. But when I got there, I just found it to be a very interesting place, very smart colleagues, interesting work, and have found my home there since then. I was also happy that the firm was a big supporter of pro bono work, which I was very interested in, including a substantial pro bono asylum project. And over time, the firm supported my ongoing involvement in the immigration bar, where I became involved in national leadership, first on the board and then as an elected officer. So that's where I am now. I'm a partner in Sidley's immigration practice, and finished recently, as you said earlier, Professor Brandt, the national president term of the American Immigration Lawyers Association.
Yeah, well, you've had a wonderfully rich practice dealing in a lot of areas. Let's turn to the law and what's been happening in terms of your topic. Now, in 2016, Donald Trump based a lot of his campaign for president on immigration issues. And he kept that focus throughout the 4 years of his presidency. It must have been really quite interesting to be the national president of the American Immigration Lawyers Association during the final year of the Trump administration. What did you see as the main impact of the Trump administration's policies?
Well, Professor Brandt, it was definitely interesting. And I have been doing immigration law long enough to have observed immigration policy through a series of presidential administrations, both Democrats and Republicans. And I think you can certainly say about immigration that it's not a strictly partisan issue. And during my life, I've seen Republican presidents like Ronald Reagan and both of the presidents Bush, who, of course, were law enforcement oriented, but at the same time valued and welcomed the contribution of immigrants. The famous amnesty program of the 1980s came under President Reagan. And President George W. Bush, before he became known for the Patriot Act and some of the immigration enforcement initiatives, particularly with respect to the Muslim community, before that, President Bush was set to sign a framework agreement with the president of Mexico to liberalize immigration policy between our two countries in September of 2001, of course, until the planes hit the World Trade Center on 9/11 and everything changed. And the bilateral framework with Mexico went out the window, and we went into the post 9/11 immigration area. But having said that, the Democratic presidents have mixed records on immigration as well. President Clinton pushed for empowerment of immigrants and greatly expanded support for the naturalization program. But at the same time, he moved forward legislation that significantly increased the punitive impact of crimes in the immigration system that we're still functioning under today. And President Obama, who promised to make immigration reform a cornerstone of his administration, was not successful in passing immigration legislation in Congress. And while his administration created the DACA program, it was also widely criticized by immigration advocates for the way it handled the migrants at the southern border. So all of that is to say that immigration's always been a complicated and controversial bundle of issues that doesn't align neatly with party lines or party platforms. But sort of bringing it up more to the present day, something did really seem different during the 2016 presidential race when candidate Donald Trump really repeatedly said that immigrants were stealing U.S. jobs, that immigrants were criminals, in short, that immigrants and immigration were a threat to our country and to our economy. And we didn't really hear much about the value of immigration. So when candidate Trump became President Trump, we had a lot of questions about how that anti-immigrant rhetoric would transfer into policy and into action. And we did not have to wait very long. At the end of the first week of the Trump presidency, on a Friday afternoon, I remember it like it was yesterday, the Muslim travel ban dropped. It was the first of a staggering number of anti-immigration executive and administrative policies. By some counts, over 1,000 measures were issued in terms of executive action by the Trump administration. And you all may recall the huge response in the country when the original Muslim travel ban was issued. Students and refugees and physicians and business people from the subject countries were stuck outside of the United States in a panic. There were protests around the country. There were lawyers going to airports to try to help travelers who'd gotten caught up in the ban. It was really a memorable event. And I was contacted at that time by one of my clients, an in-house lawyer for a global corporation who had been planning for months with a group of other moms in her Chicago neighborhood to sponsor a Syrian refugee family who was supposed to travel to Chicago the following week. And the moms had put together an apartment and decorated a nursery and collected food and toys to welcome the family to their community. And half of the family, including the grandmother, had arrived already. But the husband and the wife and their young child were stuck and stateless in transit at a refugee camp in Turkey, and the whole family was terrified. And so I worked together with my client for 2 long weeks to try to figure out how to get this family to the US. There were lawsuits being filed, and one day it looked like it might be possible to come in through Boston, and the next day through another port of entry. It was just complete chaos and very, very unsettling for everybody. And we finally got them in, and I will never forget the evening that my associate and I, who'd been working on the pro bono matter, stood at Terminal 5 at O'Hare Airport, watching the family finally come in through the sliding doors to a cheering and tearful group of family members and the Chicago Neighborhood Mom Group and a slew of reporters. And there were tears and hugs, and that story had a happy ending, but the emotions and the fear and the drama of that moment just seemed to repeat itself many times over the next few years. And what most of the Trump administration initiatives over the next 4 years had in common was that they came in the form of these kind of executive actions. So just to run through some of them, soon after the Muslim ban, there were other orders and proclamations to cut refugee admissions, to conduct extreme vetting, and to slow the pace of visa processing abroad. An executive order called Buy American, Hire American followed, called BAHA. BAHA did not actually include a specific directive on immigration policy, but it mandated the federal government to view all immigration policy and programs through the lens of immigration being a threat to U.S. workers, and had really a broad cultural and political impact on all of the agencies involved in immigration to skew their interpretations of existing statutes and existing regulations in a way that really profoundly impacted the immigration system. The legal immigration system that was in place when the Trump administration stepped into the White House was, as it always has been, sort of a messy conglomeration of laws and regulations and policies that have been developed over time to address what our countries needed from the immigration system. And what we saw as immigration lawyers during those 4 years was that the administration, in really an truly unprecedented way, looked at each part of this immigration system with a legal and procedural magnifying glass and sought to use executive action to reshape the system in truly new ways. And some have called the architect of much of this Stephen Miller, the master of the dark bureaucratic arts, due to his ability to understand the detailed intricacies of the immigration system and figure out new ways to shut it down, or at the very least, throw enough sand into the gears in an attempt to grind the system to a halt. One of the key priorities of the Trump administration was to stop asylum and to seal the southern border, and to shut down the asylum process at the border. Early on in January 2019, the administration put into place the Migrant Protection Protocols, or the MPP. And the MPP program made individuals ineligible for asylum if they traveled through other countries, and also required asylum seekers to remain in Mexico while they waited for their hearings. And you probably all saw this on the news. This led to the formation of squalid tent cities in places like Matamoros, Mexico, across the border from Brownsville, Texas, where people waited for months in makeshift refugee camps to be able to apply for asylum at a hearing before an immigration judge. And to keep the applicants from entering the US, the Department of Homeland Security erected tent courts in the border cities where the asylum applicants would be called to appear on video before an immigration judge. And when I was AILA president during that year, I led a delegation to serve as legal observers in the tent courts and to visit the refugee camp in Matamoros. And it is truly an experience that'll be etched on my memory forever. We crossed the border into Matamoros to meet with some of the families who were living in tents with small children in fear of criminals and the cartels. It was just shocking that the policies of our country had created this situation. Although I have to say, it was also very inspiring to meet with the brave and committed lawyers, local lawyers and volunteers who came in from around the country who were pledging their time and their resources to work with these vulnerable people. But it was really shocking to see it. Now, keep in mind that what I've just described is how the administration dealt with people coming to the U.S. border who were turning themselves in and requesting asylum at the port of entry. And for those who were attempting to enter the U.S. without inspection, the administration had a different plan. It instituted its zero tolerance policy, where the Department of Justice instructed federal prosecutors to prioritize the prosecution of immigration crimes, including the crime of an illegal border crossing. And as it began to apply the zero tolerance policy to the crossers that it apprehended at the southern border, if there were children traveling with those adults, those children were separated and detained while their parents were undergoing these proceedings. And that policy is where the humanitarian tragedy of the family separation program was born, in an initiative that ultimately separated more than 3,000 children from their parents, some of whom, as you've all, I think, seen recently in the news, remain separated to this day. The formal family separation policy was ended by executive order in June after a massive public outcry based on what people were seeing in the media of the children that were in detention facilities. But even after it was ended by executive order, family separation continued where it was deemed to be needed for cause. Of course, there was also a lot of enforcement activity going on beyond the southern border. There were also the 11 million undocumented people living already in the United States, and the administration sought to streamline the process to detect them, apprehend them, and remove them, and issued an executive order to make everyone a priority for deportation, as opposed to previously where the agencies were supposed to focus on people with crimes and serious crimes and people with recent deportation order. And by deprioritizing and making everybody a priority, it moved a lot more people into the deportation system. The administration also used the Department of Justice to reshape the deportation process as a tool, both in terms of law and process. The Department of Justice runs the immigration courts, which are housed in the Department of Justice's Executive Office for Immigration Review. And under the Trump administration, from an administrative standpoint, the Department of Justice exerted a lot of pressure on the immigration judges to increase the speed of their adjudications and to limit important aspects of due process for the respondents. And particularly under Attorney General Jeff Sessions, the Department of Justice took new steps to restrict immigration through substantive changes to the law by taking certain pending cases up to the AG and having the Attorney General himself set precedent decisions by which he narrowed the definitions of asylum that had a lot of impact on applications, and also ended and limited the judge's ability to administratively close or terminate cases. One issue that was talked about a lot during the Trump administration, which was kind of a complicated issue politically for the administration, was DACA, the Deferred Action for Childhood Arrivals. And during the campaign, candidate Trump had promised to immediately end this Obama-era program that protected Dreamers from deportation and provided them with temporary administrative status. At that time, he said that President Obama had overly used his executive action powers to establish DACA, and that he would rescind it immediately. It did take a little bit of time, again, because it was politically a little bit more complicated. There was a lot of sympathy, much more so on a bipartisan way than for other immigration programs for DACA. But the president, under pressure from his base and some some of the states that were pushing for this formally withdrew DACA in September of 2017, which was then followed by a long and very complicated court battle that involved cases that went all the way up to the Supreme Court. And ultimately, DACA was kept alive, but we'll talk a little bit more about litigation later. In addition to the attempt to limit asylum and streamline the deportation process, there were also a lot of restrictions that we hadn't necessarily anticipated on the legal immigration process. And one major initiative of the Trump administration in the legal immigration area was a new regulation to impose a wealth test on legal immigration through the public charge rule. And here, the administration used the formal regulatory process to issue a regulation barring foreign nationals who are deemed to receive public benefits from becoming permanent residents. And for those of you who are not aware of the ins and outs of the public charge rule, there was already a public charge bar in the statute, which had been on the books for a very long time. And family-based immigrants already had to establish that they exceeded certain poverty level guidelines or had sufficient financial backing through a sponsor in the United States. But the public charge regulation that was promulgated under the Trump administration imposed a significant number of requirements, including running a credit report and documenting extensive assets and liabilities and much more. And these were requirements that really would have a disproportionate impact on the elderly, on women and children looking to immigrate into the United States. And at Sidley, I practice in the business immigration area, and the public charge rule certainly made a big impact even on the primarily degreed professional foreign nationals that we work with. It just was very, very burdensome. And in addition to that, we saw a lot of changes that created new hurdles for employers seeking to hire foreign national talent, again, in the business immigration area that I practice in day to day. We saw additional vetting and other impediments to efficient processing of cases, including a brand new personal interview requirement that hadn't existed before. We saw the hostility towards the H-1B program, which is the work visa that's used for professionals in IT and STEM and other professions, and just saw that it became harder and harder to get cases approved, even though there had been no change in the statute and no change in the regulations. But again, through this lens of the Buy American, Hire American, and other ways that the immigration process had been politicized, it just became harder and harder to do this. And the delays and the processing issues became so bad that the House held hearings on the topic. And I actually, one of the things I got to do as president of AILA was having the privilege to testify on the Hill about the delays and what we were experiencing as practitioners in terms of just unacceptable impediments in the process. So that was the framework that was in place in a good chunk of my first term of my presidency of AILA. And then, of course, in the winter of 2019 and heading into the spring, 1 year ago, we all know what happened. Out of nowhere, suddenly the pandemic stormed into our lives and disrupted everything and affected everything. And it was obviously a very difficult time for everybody. It did have particular challenges for immigration lawyers. While many of our workplaces shut down and we were under stay-at-home orders, the agencies kept going. We still had filing deadlines. Our clients' statuses needed to be extended. Court cases were still proceeding, even as COVID was ravaging the country. So we had a lot of work to do, not only dealing with the Trump restriction provisions, but also as a bar association, taking care of our members, trying to get accommodations from the agencies on extending client deadlines, trying to keep our lawyers and our clients safe in the court proceedings that were moving forward. And we also had to give ourselves and our members a crash course in the new government loan programs and crisis management and disaster responses, because many immigration lawyers are business owners and we're working very hard to keep their employees paid and their practices afloat. At the same time, the administration also seized on this unique political moment with a nation that was gripped in fear during a pandemic and job losses and unemployment and an economy that looked like it was about to go into free fall, to use that moment to push out more restrictive executive measures on immigration, using the pandemic as a justification at that point, including a number of COVID-related travel bans, bans on entry for certain immigrants and certain work visa holders from abroad, and regulations restricting the use of the H-1B program and substantially increasing wage requirements for that program. And these were regulations that had long been in the works, but now were suddenly being published as interim final rules, which is an extraordinary procedural measure that bypassed the regular notice and comment period in the regulatory process, using the economic impact of the pandemic as a justification. So I guess I gave you a very long answer to your question, Professor Brandt, but I think the bottom line is it was certainly interesting and challenging and a very unique experience to serve as president of the National Immigration Bar during that time.
Yeah, it was a lot happening in immigration during that time. And you said a little bit about how it affected your practice. Perhaps you can elaborate on that a little bit. And quite often when new obstacles are implemented, new tools are developed in response to them. Were there any new tools that immigration lawyers and advocates developed during these times?
Yeah, absolutely. So yeah, I did say, I think already a little bit about how challenging the day-to-day work as an immigration lawyer was for me and for many of my colleagues. All of the executive actions and executive orders and presidential proclamations and announcements, there were just so many. And it seemed that during some of those periods, there was an announcement of a major new unexpected change. Sometimes it seemed like almost every day. And it was from a practitioner standpoint, it was challenging, it was exhausting, it was often demoralizing. It was really hard to see the impact on our clients. Each of these measures was designed to have as much impact as possible on immigrants in the US, on their families abroad, on US employers with foreign national employees. And they did. We saw it. We felt it. We felt it every single day. I think it's, in all my years, probably been without a doubt, the toughest time to practice immigration law, both because of the impact on our clients, but also to see the tools that we use, the options that we typically can present to our clients, the ability to be creative and resourceful lawyers, to see all of those diminish and be cut back with these restrictions day after day. So that was really difficult. But in terms of the development of new tools, what was really exciting about this time is that as an immigration bar, we began to look at ways to address and respond to the situation in ways that we hadn't done before. Because one thing that we realized in studying these measures as they were issued by the administration was that these executive orders and memos and policies, this whole arsenal of executive actions, much of it was pushed out aggressively. It was designed for maximum legal and political impact, but in its haste to overhaul an immigration system whose foundations are in a statute and where the specific legal requirements are in place to issue regulations and change existing policies, often the administration took shortcuts procedurally and, as it appeared to us, overreached its executive authority. And sometimes to the point where it just looked like it flatly contradicted the foundational statutes that our system operates under. So the immigration bar got to work and, together with other organizations, developed a serious, coordinated, organized litigation response to many of the executive actions and initiatives that I just described. And almost all of the programs that I just talked about were challenged in federal court, some by AILA, some by other organizations, some by states, some by pro bono litigation teams, some by individual plaintiffs. And what we saw in the area of impact litigation was truly, truly something new and something exciting. We saw litigation challenges and injunctions on a number of the key signature Trump administration initiatives. I'd mentioned already earlier the DACA litigation, which was long and complicated and went up and down to the Supreme Court. The litigation is actually still going on in the case that began in Texas, but the injunctions have been lifted and DACA is alive now due to the litigation efforts of states and advocates around the country. And I'm not sure where that litigation will go, but DACA is really an issue that has always needed to be solved by legislation, not by litigation. It's always been vulnerable as an administrative program, as we've seen, and hopefully we'll see something more of a legislative solution in the future. The MPP program at the border that I mentioned earlier was challenged in a number of lawsuits. The Trump administration's midnight rule that would have severely restricted the asylum program was enjoined by the courts. There were a number of litigation challenges to the public charge rule, which has now been taken off the books as a result, in large part because of the litigation. And I would say the day-to-day impact of these litigation challenges had several different aspects. First of all, there were a number of critically important injunctions that stopped the impact of a number of these rules and programs, some permanently, some for periods of time. Regardless, protected a significant number of people from the harmful impact of these rules. But I think also more fundamentally, the litigation efforts were so important to the immigration law community and to our clients to know that we were fighting back, to know that these issues were being heard in court. And for those years of dealing with an agency and an administration that didn't seem to care about our concerns and our clients' concerns about the impact, the very difficult impact that these policies were having, they had to listen when the case was in court. And that was so important to all of us, whether we had victories in court or not. And while not all the cases were successful, there actually were a lot of victories, some of which had broad-reaching impact and some of which just kept us going when it seemed like the days were really dark in some of those times. And another really exciting development, I've been talking a lot about impact litigation, but also during this time, the immigration bar began to take the denials of individual cases to federal court. For example, if I worked with an employer and filed an H-1B case, this may even have been an extension for an employee who had already held that status for some time. And suddenly we saw a denial that didn't seem to be based in the facts or in the law. In past times, a lot of times employers would have just sort of let that go. And now a lot of these cases started being taken to federal court for the federal judge to take a look at whether the agency had abused its discretion in denying these cases. And that was a whole new movement within the immigration bar. Practitioners were now taking these denials of these individual cases to federal court and having a lot of success. And often the government just approved those cases before they were actually reviewed by the federal court, as often the federal judges, if they actually saw the merits of the cases before them, did not look kindly on these denials where the government had elevated the standard and often disregarded evidence and issued decisions that were pretty hard to defend when the daylight of a federal court proceeding shone on the decision. So that was another thing that really changed within those 4 years, was immigration lawyers taking cases to court and helping their clients, and also making law on some of these issues where the cases actually were litigated. So I would say overall, the litigation efforts really changed the legal landscape in a lot of ways in immigration during those years, and really affected our mindset as an immigration bar. And I believe will change the approach of both immigration lawyers and others for many years to come on how to deal with some of these policies and these types of policies.
Well, you described the Trump administration as having made changes rather rapidly, and you indicated on a day-to-day basis at times on immigration rules. And that indicates that the executive branch can have a huge impact on those rules. Of course, Congress can too, and you've talked about the role of the courts, and we get into the courts through the role of the lawyers. With the new administration, with the Biden administration, all of this affects policy as well as carrying out the law. What do you see as the big issues of policy, and has the Biden administration made the changes they promised to make?
So, yeah, I mean, that's what we've all been thinking about now these past couple of months. And the Biden platform was very ambitious and extensive, and included a very ambitious and extensive immigration platform. And it covered many areas. But in reading it, we did see that it focused most on DACA, on a path to legal status of the undocumented population, dealing with the previous administration's MPP protocols and the humanitarian issues at the border, and preserving asylum. That appeared coming into the presidency, what the platform focused on. And that is where most of its efforts have been focused on since the inauguration. And there's a lot to do, and the president and the administration have done a lot. But again, the focus seems to have been primarily in those areas. In his first weeks in office, I think both substantively and symbolically, President Biden issued several executive actions focused on reevaluating and unwinding a number of Trump-era policies through executive action, including immediately rescinding the Muslim ban, reestablishing priorities again for deportation, and also imposing a 100-day moratorium on removals, suspending the MPP program at the southern border and creating a regional framework to address migration issues, establishing a task force to help reunify families, issuing an order directing DHS to preserve DACA, and also from a business immigration standpoint, importantly, pausing a number of those midnight regulations to study their impact, including some of the ones that we were very concerned about relating to H-1Bs and other business issues. And very importantly, the Biden administration stated that it would no longer defend the public charge rule in court. That litigation was still ongoing, and related to that, struck the regulation from the book. So those have all been important developments. Some of them are more operational, some of them are more symbolic, but those appear to be the priorities at this time. But despite these early executive measures for the Biden administration to meet even some portion of its campaign platform on immigration, it's going to take a lot of work. There are still remnants of the MPP program that need to be phased out that can't just be eliminated through an executive order. The U.S. refugee program needs to be rebuilt. The damage done to foreign student enrollment and a lot of these other ways that this hostile environment towards immigration just affected so many different sectors. Just a lot of work remains to be done there in important areas that affect our economy and our country. Some of these changes will require regulatory activity, such as the asylum rule that the Trump administration issued. The asylum rule is enjoined. The Supreme Court enjoined it in 2020, but it's still on the books, and that and a number of other measures will take regulatory activity to unwind. And it's also the administration is going to need to begin the hard work of changing the culture of the agencies that spent the prior 4 years operating under political appointees that embodied that Baja anti-immigration perspective. And a lot of personnel on the ground, again, as I said, it's really going to require some work in terms of a cultural shift for ICE agents and USCIS adjudicators and consular officers abroad. Just because a new administration puts in new political appointees at the top doesn't mean that the culture changes overnight. And that's really important in the work that we do, because so much of it has to do with the actions of individual agents and adjudicators and other personnel in the bureaucracies. I'm convinced that litigation will continue, and I think it's going to continue sort of from both sides, if you will. I think from those that oppose this new administration's executive actions, I expect that they saw the success that we had litigating through litigation, challenging a lot of the prior administration's executive actions. And I think they'll be ready to pose challenges from the other side. For example, President Biden's deportation moratorium already has been challenged and enjoined in federal court. So I think we're going to start to see much more of that, challenging the current administration's executive actions. But also for those of us who would like to see continued improvements in the implementation of the immigration system, we're not always going to see eye to eye with this administration's implementation or execution or priorities. And I expect that impact litigation as a tool to move forward ongoing priorities from the immigration advocacy community and from the business groups is going to continue to be a tool in the arsenal as well. But I think fundamentally, the Biden administration understands that the real change in the immigration system, both in terms of reversing the policies of the prior administration, as well as something that needs to have happened a long time ago, which is updating and improving our very outdated immigration system, really needs to come legislatively. And the Biden administration did promise a day one comprehensive immigration bill, and there is a comprehensive immigration bill that's that the administration has been working on with leaders in Congress to put forward. It's comprehensive, it's very detailed, and it will need to secure bipartisan support, of course, with Congress being as divided as it is, and the complexity of immigration politics and the fact that they're not purely Democrat or Republican issues. I think we're all wondering what the future is of this very extensive, comprehensive immigration bill. And I do think it's optimistic to think that this bill in this form will pass with all of its components intact. But I do think it's really important to have the bill out there. Hopefully, some portions of it will be enacted as legislation. I think it also serves a marker of what the current administration believes is important in terms of not just fixing some pieces of the process, but fixing it as a whole. And my hope is that some of the critical components of that bill become law, such as the path to status for Dreamers and others that have lived in the US for a long time, just improving our outdated quota systems, both for work visas and for green cards, to better reflect our reality of today. I mean, a lot of those provisions were put into place many decades ago, and they don't reflect the reality of our workplace, of our travel patterns, of what our economy needs, of what our family reunification needs are. It just needs to be brought up to date, and to otherwise build a system that just better serves the needs and the values of our country.
Which raises a question, I think for a number of years, there's been discussion about the need for comprehensive immigration law reform, but it just doesn't seem to happen, which means that the door is continued to be open for executive actions that can be reversed in the next administration. Do you, and I know that through your work as an officer of the American Immigration Lawyers Association, you did advocacy as well and work for change in the laws. Do you see is there a real possibility of either bipartisan change or even change that's not bipartisan? And what's possible over the next few years?
Yeah, so that, of course, that's what we're all talking about. I think there are some issues that already for a long time have had bipartisan support, but for various reasons haven't moved forward. I think there's a lot of support for providing some sort of legislative relief for the Dreamers, for the people who were brought as kids by their parents to the United States and have really grown up to be part and parcel of the fabric of our society. And I think there's a lot of support, and I think there has been all along, but there have been sort of political impediments to passing legislation, and certainly over the past 4 years, a lot of political impediments. So I think there's hope that those kind of provisions will move forward. I think from the immigrant advocacy community, the hope is that the advocates can sort of remain together and not be splintered off into different sort of subsets, because it is really important for the system to change as a whole instead of piecemeal. And so I guess your question was, do I see that it has a possibility? I certainly think it has a better possibility now than it did over the past 4 years. But it's going to take a lot of work, and it's going to take a lot of effort on the part of also companies to advocate. One thing that I have found really interesting over the past 4 years is that it looks like companies, the business community has become also more emboldened to litigate and has also become more committed to doing advocacy politically on some of these issues. In fact, I do a lot of work up on the Hill, and I've seen companies really go to bat for, especially for Dreamers and for DACA. It's something that's been very important in terms of their diversity initiatives, and the business community has been really committed to it. And that's something that I've seen as a shift that I think gives some hope that it's going to maybe pave the way for some of these immigration issues being more bipartisan.
I want to again invite our audience to put questions in the Q&A or the chat function. We're reaching the end of our time, but we still have a little bit of time that we can deal with that. But let me take us in a little bit different direction here, Marketa. With the pandemic, I mean, my work involved a lot of travel abroad, and that's all been gone in the last year. And it has kept me from seeing what I often saw, and that was the opportunity to talk with others from other countries about how they view the U.S. and U.S. policy, and how certain areas of policy affect how we're viewed by other countries. I would assume that you, when you were president of AILA, you had some contact with others across the globe. What's your impression of how others see these changes in our approach to immigration policy from outside the country?
You mean as we've transitioned to the new administration?
Well, yeah. How has it been seen, and how do you think it's being seen at this? What's the perception of the United States in terms of immigration policy on a global basis?
So I think certainly under the 4 years of the Trump administration, I heard primarily that that we were being viewed as very protectionist, and that all of the travel bans and all of the complications for people being able to come to the United States were really affecting commerce and international relationships. There's an opportunity now, I think, for the current administration to rescind some of the travel bans. And interestingly, it's rescinded some, but not all of them. It's rescinded a travel ban, the Muslim travel ban, of course, right away. There's also a travel ban that's still a holdover from the previous administration that restricts certain types of visa holders to come into the United States, even though they've already been approved for, let's say, an H-1B visa. That still remains in place. So it'll be interesting to see to what extent the current administration is committed to undoing some of those aspects, which really, I think, affect the ability of other people to come to the United States, to work here, to do knowledge sharing and cultural exchange and so on. And, you know, it'll be also interesting to see, I know we've had, and you probably know more about this than I do, Professor Brandt, but I know it's had an impact on foreign students and their interest and ability to come to the United States. And that is a very significant part, I think, of our cultural exchange with countries abroad. And hopefully we can right that between the pandemic and our immigration rules. Hopefully we can put that back on track.
Yeah, I can say that here at the center, we're dealing daily with issues about students who want to come to Pitt Law to study, and questions about whether or not they can first get the interview they need at the embassy or consulate to get the visa, and then whether they can get the visa. And it has changed. And I also think that the past few years have put us in a less competitive position in terms of legal education on a global basis. And I don't think that's a good thing for the United States. I think that the kind of people we can train and send back in those instances can have a huge impact. But it is, you know, when I look at that small aspect of it, I really do appreciate the way in which you and your colleagues in the immigration bar have worked to make proper immigration possible. And I hope that we can return to a place where that happens, where we can have the students here who then can be educated in return to make a difference.
Yeah, absolutely. And I think that the work visa rules factor right into that too, because I think a lot of students understandably make decisions where they're going to study, depending on whether there are also going to be opportunities to be able to continue their careers in those locations. And I think even just the hostility towards the H-1B visa program and some of the other work visa programs have sort of a downstream effect on foreign students as well. And I think all of this is bad for innovation in the United States. I think it's bad for our educational system. And and it's not good for our employers either. So, obviously and I think a lot of my colleagues feel very strongly that that this is really important, not just because it's important and the right thing to do for our country, but that it's very important economically as well.
Yeah. Well, no, I think economically it's huge, and certainly just the economic impact. People don't realize the importance of the export of education as an economic export to the United States, and that's been severely curtailed in the past few years, and it's not the pandemic that's been mainly responsible for that. So again, we do appreciate what you and the American Immigration Lawyers Association have done. We are reaching the end of our hour, and I'm not seeing questions that we've left unanswered. You've done a great job of answering my questions, Marketa. You've done a great job of demonstrating what someone can do with a Pitt Law degree, particularly if they were advised while they were here by Professor Lobel, as you were, and I think that's evident in your trajectory, and so we are certainly quite proud of all that you've done. Want to thank you for taking the time to be with us today and share not only your experience but your insights, and we thank you for the work that you continue to do. As with our other McLean lecturers, I normally at this point at the podium hand you a gift, and that gift is the same for every McLean lecturer. That is a clock to remind you of the time you spent with us, but we try to make it a special clock. So because the McLean lecture exists to try to indicate that peace can come in peaceful ways if it comes through law, we embed in the clock a piece of the Berlin Wall to demonstrate and peaceful change and development on a global scale. And so I can't hand it to you now, but you will be receiving that. I can tell you that I've seen that clock when I visited the President Judge of the International Court of Justice on his desk at the time. I look forward to seeing it on your desk when I get a chance to visit you in Chicago. But again, thank you so much for joining us. It's been a wonderful talk, and we very much appreciate you coming back to Pittsburgh.
Thank you very much. It was really a pleasure. Thank you.
Okay, we look forward to having you back in person and seeing you again. So thank you, Marketa, and thank you to everyone who joined us. Thank you, Dean Amy, for the welcome and introduction. We look forward to seeing you all at our next McLean lecture, but even before then at our programs that I mentioned in April and May. Please do join us for the other events that celebrate the 25th anniversary of the Center for International Legal Education. Thank you all.
Thank you.
Bye-bye.